Good morning.
Good morning.
Everybody can hear me?
Yes, sir.
Okay, great. All right, welcome to a oral argument session of the 5th District Court of Appeal. Today is Law Day, and we have Barry Law School has tuned in, as I understand, to watch today's oral argument session. And the panel will join the Barry Law School students after this via Zoom for Law Day. So thank you for participating today, counsel. And with that, we have our second and final case of the day, 2877 Nations Lending versus Negron et al. And with that, counsel for the appellant, if you would just let me know how much time you'd like in rebuttal, I'll attempt to remind you when we get there.
5 minutes, please.
Okay. Again, you should watch the clock as well, but I'll try to assist you in that regard. And whenever you're ready, you can proceed.
Thank you, Your Honors. Allegronoff on behalf of the appellant. We are here today on our appeal with regard to a involuntary dismissal of a residential mortgage foreclosure case. The case involved an FHA loan. Pursuant to the terms of paragraph 24 of the mortgage, the lender was required to provide the borrower notice of acceleration. The terms of the mortgage in paragraph 24 require notice of the default, action to be required to cure the default, a date not less than 30 days from the date notice is given to borrower to cure the default, and that failure to cure the default could result in acceleration and foreclosure. The issue in this case was based upon whether or not that paragraph was complied with properly. In exhibit number 4 of the evidence admitted at court was the demand letter. The demand letter was from Loan Care, and it provided on the very first page amount due as of the date of this letter, $3,401.22, and it said current first principal balance, approximately $206,000. So it provided the reinstatement amount as well as the outstanding unpaid principal balance, and it went on to advise the borrower that if they needed to pay the $3,401 to reinstate, but because of interest, late charges, and other charges that may vary, the amount due on the day you pay may be greater. The court had an issue with that, and also had an issue with the second page that just said that if you do not cure the defaults on before the specified date, the total outstanding balance will be due. The court held, in its opinion, its ruling, that the default letter did not substantially comply with paragraph 24 because it was confusing. That was the court's determination. There was never any discussion of prejudice, any discussion of any of the evidence about what the borrower actually knew. And the court—
Ms. Knopf, if I could interject, I understand it's clear the trial court focused on the confusing nature of acceleration and the amount due to cure. Does paragraph 24 require the lender to advise the borrowers of their right to assert the non-existence of a default?
It does, Your Honor. However, that's not the basis of the trial court's ruling, number one. The court—
Does the demand letter discuss that, or will you interpret it to advise them of their right to assert the non-existence of a default?
No, sir. I will concede that it did not state that the borrower had the right to contest the foreclosure and assert the non-existence of a default. However, in this case, there was no prejudice ever to the defendant. The defendant did have competent counsel from the beginning.
Ms. Knopf, I have a question about your prejudice analysis and where the burden lies and when. If the lender, if their non-compliance with the condition precedent is material, does it matter? Does the borrower then have to prove they were prejudiced, even if your compliance, even if you do not substantially comply with the condition precedent, does the burden still shift to the borrower to prove prejudice?
Well, whether or not there was substantial compliance, we would argue that there was substantial compliance, just as in other cases there have been substantial compliance when there was a technical technical issue with regard to the letter. But prejudice, I believe the 5th DCA has held since 2016 that prejudice is one of the factors that the court must examine. Specifically, I think the case most important in this case is Diaz versus Wells Fargo, in which which Your Honors found that the breach letter was sufficient, even though it may have been confusing. And the
Well, isn't
court
that
noted that
tantamount to a finding of substantial compliance, meaning they met that burden prior to even going on to address prejudice?
yes, sir, there was substantial compliance, but there's nothing, I
interpreted Judge Nardello's question to be, do you even reach prejudice if you haven't met substantial compliance? And if I put words in her mouth, I apologize.
Thank you.
All right, I see what you're saying. Well, the substantial compliance, the definition of substantial compliance that I have is that it's performance that may not be full, but is equivalent to what was bargained for, so that it would be unreasonable to deny the other party the benefit of the bargain. A technical breach is immaterial. And here I'm citing Green Tree Servicing versus Malam. And I would argue that this was a technical breach, because if you look at the record, the record is replete, for example, with the collection notes where she called repeatedly, that the borrower called repeatedly to find out how much was necessary to reinstate. She never demonstrated any prejudice. She was competently.
But counsel, you're talking about prejudice again. I think we're still trying to establish whether we even get to prejudice if there's no substantial compliance.
Well, substantial compliance, I believe, was met because she was informed of.
Right. No, I understand your argument is I understand your argument is sort of twofold, but just as far as the law goes, let's talk about if there was no substantial compliance. Let's say in a case, or if this panel determined there wasn't substantial compliance, do we even then analyze prejudice? That's the question that I think we're trying to get answered here initially.
I believe that they both go hand in hand, and I'll explain why. For example, there's the case about in Bayview Loan versus Servicing versus Hefner. It said absent prejudice, breach of a condition precedent does not constitute a defense to a valid contract. So that to me would mean that even though there was a technical breach with a demand letter in terms of not providing one notice, that still that's not grounds to invalidate, to deny foreclosure, because it was not substantial, it was not material. That's my main argument, is that it wasn't a material breach that in any way impacted the borrower. She had competent counsel. She knew of her rights. She demonstrated that by calling on the collection log, or notes which were admitted evidence, showed that she repeatedly called to
determine. Do you think there's a difference in the concepts between the concept of prejudice and the concept of materiality? Do you think that there could be a difference between those two?
Can you repeat that, please?
Yeah, the concepts of prejudice and materiality. The way you're sort of arguing it sounds like you think those are one and the same. And I just wonder if that's accurate. I wonder if they are actually separate concepts, and that materiality might apply to whether or not there is substantial compliance, right? And whether the lender substantially complied.
Right.
And then prejudice might be, even if the lender did not substantially comply, did the borrower suffer prejudice based on what they did or didn't do?
They are distinct, I believe.
So which case is it that you sort of latch onto to suggest, to support your argument that even if there isn't substantial compliance at all by the lender, that we still look at prejudice?
Well, Your Honor, our argument has been that, well, I did want to point out that the court, our position is that the court erred when they found that there was not substantial compliance, merely because there may have been something confusing. I just want to make that clear.
That is not lost on us. We understand. We're just trying to get an answer to, sort of, if the panel ended up not agreeing with that, do we go to the prejudice analysis?
Well, I think that with regard to, one of the issues also is how you're going to determine substantial compliance. And this is an issue that we kind of grappled with, because, for example, there's case law out there that says that all you have to do is compare the letter with the actual demand, with the terms of the mortgage, and that's a legal determination, a pure determination of law. But then again, it may not be, and in this case, it's not, because there was not that analysis done. So it seems more of an issue of fact. And as a result, I think whether or not there was a material breach.
I mean, can't we just look at the mortgage and the notice letter and decide that? What other facts would there need to be?
Well, it goes back to the prejudice.
But no, we're talking about, okay. I guess we're sort of still trying to get the answer to, if there's no substantial compliance, do we even get to prejudice?
I mean, strict compliance, I think, is usually required. And in the absence of strict compliance, substantial compliance will do in the absence of prejudice. Do you think that's an accurate statement of the law, Ms. Knopf?
Can you please repeat that, Your Honor?
Strict compliance is usually required, but substantial compliance will do in the absence of prejudice.
In the foreclosure context, I would say that strict compliance is not required. Substantial compliance is required. Substantial compliance, and if there's not, even if there's not substantial compliance, however, the case law has indicated that there still has to be proof of some sort of prejudice. There's a case, I'm trying to find the name of it, where the
Counsel, what if you didn't send the notice letter at all? Well, hold on. What if you didn't send the notice letter at all? No letter whatsoever. But given the facts of the case, it becomes clear that there was no prejudice, that the borrower knew all of their rights. They even admit at trial, yeah, I knew all of my rights. I knew that I could defend. I knew everything. I knew it all, and I did it. So there was no prejudice. Then under your analysis, no harm, no foul, lender can foreclose.
That's correct.
So as did, I think you kind of, I don't want to use the word concede, but I will. I think you conceded a technical insufficiency for not advising the borrowers of the right to assert the non-existence of a default, right?
That's correct.
We kind of confronted that at the outset. So secondarily, do you make that same concession with respect to advising the borrowers of their right to assert defenses? I think your agent at trial did.
That was not in the letter, correct?
Okay. So those are two areas of technical deficiency that, notwithstanding them not being there, you allege substantial compliance, right? I'm just trying to get a handle on the world of technicalities that you say ultimately don't matter because it's substantially complied.
Correct. What we're arguing is that it was a technical error, and because there was no prejudice based on the record, that the court erred in finding that there was not substantial compliance. But I did want to point out that the court did not get into, in its ruling, the court seemed to be focused on the amounts due in the letter, not as to with regard to the right to defend.
I mean, is it your position that this court could not also consider the other deficiency based on the tipsy coachman doctrine? And if the tipsy coachman doctrine doesn't apply here, why not?
I don't want to say that the court can't consider the tipsy coachman doctrine, but I don't think that it would. My concern would be that it would actually be more confusing if the court did so, but I'm not saying that the court can't rely on that. That's not my argument at all.
The trial court, in other words, I mean, it's on the face of the record and would support the trial court's ruling. So, I just don't know if there's an argument. Tipsy coachman isn't always appropriate, but when there's something on the face of the record to support the trial court's order, then I mean that's sort of a classic or general example of when tipsy coachman would apply. So So is it your position? I mean, what if we considered both? I mean, if we do think the tipsy coachman doctrine applies and we consider both deficiencies, you know, do you still take the position that it's not, that there is substantial compliance, even though one of the items is completely left out?
Yes, Your Honor, that is our position, that there was still substantial compliance because it was just a technical error and there was no prejudice to the borrower. This goes back to just the case law that says is that you cannot invalidate a contract just because of a mere technicality.
And again, counsel, I don't think I ever got an answer. What is your best case for the proposition to support your proposition, your argument that, hey, look, if there's, as long as there's no prejudice, then we've substantially complied. You know, it doesn't matter. There's no breach.
Well, I would go to Diaz versus Wells Fargo Bank, which I previously cited. If you'll bear with me one moment with my computer. Also, there, Bayview Loan Citing Servicing LLC versus Hefner, which this court decided in 2016, because it said the ruling was that absent prejudice, breach of a condition precedent does not constitute a defense to enforcement of a valid contract. And that case cited Gorell versus Bank of New York Mellon, which well, that was not directly on point. It did, the court, the 5th DCA held that defective notice is okay, even because
in Diaz, we found that there was substantial compliance. So I'm not sure that case could support your position. Don't you need a case where the court said, hey, there wasn't substantial compliance, but since there was also no prejudice, affirmed?
Citigroup Mortgage Loan Trust versus Cialba, which is a 4th DCA case, that was the case where they sent the breach letter to a completely wrong address. So the borrower never actually received it. But the court held that even though it was sent to the wrong address, because there was no prejudice, there was never any effort, as in this case, to attempt to reinstate, that there should not be, that the case should be remanded for a new trial. Another case is Pnc Bank versus Roberts.
You're into your rebuttal time, just so you know, it's up to you.
Oh, okay. I will stop then.
Okay. All right, counsel for the appellee, whenever you're ready, you can proceed.
Thank you, Your Honors. Bo Bowen Law Group on behalf of the appellees in this case. Before I touch on some of the defects in the letter, I'd like to bring this back around to what I feel is a standard of review in this case, because I think it's somewhat missed in the appellant's arguments. I don't think it is just a mere side-by-side comparison of the letter with the mortgage, because we also have testimony from the witnesses as to how they interpreted that. And I think this is a question of fact. There's case law that we cited in our brief, and in fact, I think even appellants cited it. They just had a different conclusion on it. It's the Morton case that says when you're talking about substantial compliance, that is a question of fact. The reason why that's relevant is because once it's a question of fact, it's outside this court's purview to reweigh the evidence to come to a different conclusion what the court came to. And I think that's a situation we're in. One of the big issues that the trial court had, in addition to some of the other defects that you were just discussing, is the amount it takes to cure after accelerating the loan. Now, there's 2 points here on reinstatement. One is once they first send the notice, they have to send the notice with a 30-day right to cure. So within that 30 days, if they cure, the loan cannot be accelerated. After that 30 days, the loan is accelerated, which means the full balance of the loan becomes due. However, even after acceleration, the mortgage says you're supposed to inform the homeowner of the right to reinstate by only making the cure amount, not the full balance of the loan. So that's after acceleration. You still have the right to reinstate by curing the default. That letter doesn't do that. Their letter goes the other way. And I refer to the second page of their letter. It's the first full paragraph. And this is, if you do not cure the defaults on or before the specified date above, which is the 30-day period, the full outstanding balance of your loan will be accelerated to become due in full. Well, that's correct. But here's the part. This is how you cure and prevent from going to foreclosure. Unless you can pay the loan off in full We will refer your loan to a firm in the area that will begin foreclosure proceedings in accordance with the terms of your mortgage. That's simply incorrect. So even if you did a side-by-side comparison,
Counsel, I think we can review and see the confusion as well as anybody in that letter. I guess one thing I'm curious about, I missed the case you said. What case was it that suggests that this is an unreviewable decision by the trial court?
They didn't use the word unreviewable, but the Morton case, it's Federal National Mortgage Association versus Morton. And it's
What's the site on that one?
196 Southern 3rd 428. And what it says in here is, and I'm sorry, Your Honor, that is the second DCA case. What it says in here is that regardless of whether the issue on appeal can be wholly resolved by comparing the notice letter to paragraph 22, whether a party has substantially complied with or performed the contract terms remains a question of fact. And it says, and I think this gets to the specific of our case, what I'm arguing here, there will therefore be cases in which additional facts beyond the undisputed language of the notice letter, and that can only be presented in the trial court in accord with the procedural standard applicable to the stage of the proceedings.
Sure. Isn't that referring to the historical facts? So in other words, if there's testimony that, yeah, maybe they sent this letter, but they sent it to the wrong address, or that kind of thing, as happened in the Ford CC case, that's a historical fact, right? That we have to defer to the trial court on. Is that what you're saying?
Yeah, and I think there's some facts in this case that the court relied on that I think you have to defer to, and that's why
I guess I'm just trying to make sure I understand your argument. I mean, in every case, that I can think of off the top of my head, the appellate court defers to the historical facts as found by the trial court, so long as they're supported by competent substantial evidence. Correct.
Correct.
But then in most of the time, we, as an appellate court, we take those historic facts as found by the trial court, and we determine their sufficiency as a matter of law.
Correct, Your Honor.
Okay.
The facts I think that here that I would like to cite to, I think, are why this court cannot reverse the court's judgment. I don't know how many, I'm sure you guys have heard a lot of notice of default cases where, the borrower contests that the notice of default didn't substantially comply. And there's a question, okay, well, did you call the lender to resolve this issue? Well, that actually wasn't this case. The homeowner in this case, upon receiving this confusing letter, actually called the bank to find out how to cure. And what did the bank tell them? This is per the client's testimony. The bank told them they had to pay the loan in full.
Counsel, if you could hold on one second. I'm not sure if we still have, we'll stop the clock. I'm not sure if we still have the entire panel. It looks like we may be lost a judge here. So if we could just stand in recess for a few minutes, and we will see what happened there. Okay.
Yes, Your Honor.
So we're gonna stand in recess and try to figure this out. Thank you.
Okay.
Just to let you know, we haven't gone away. We're still trying to get the judge back.
Council, just an update. Can you hear me? Okay, just an update. We're working to try to get Judge Alvaro back on. We're having some technical difficulties, obviously, and in these days that can happen, and so I apologize. If we can't get him back on in the next few minutes, then we'll I'll just tell you what we're going to do, but hopefully we'll be able to get him back on the next few minutes, either via phone or via Zoom if we can. But just sit tight for another few minutes as we attempt to do that, and we won't be too much longer. Okay.
Thank you, Your Honor.
Okay, council, just one more quick update. We're going to give it a couple more minutes. It sounds like Judge Alvaro lost power. And so that would be obviously a problem for his connection. But we're trying to work it out. We're going to give it just a few more minutes if you'll just bear with us. And I apologize again. And again, if we can't ultimately get him back on, then we'll figure out how to proceed from there. So just give us a few more minutes. Okay, I apologize.
Thank you, Your Honor. No problem.
Okay, counsel, I think we are going to get Judge Alvaro back. His power apparently is come back on, but of course, when the power goes out, then you have the modem has to reboot and all that good stuff. So I think we're going to get him back at minimum, at least by phone, if not by video. Give it. I know I keep saying this, but give us 3 or 4 more minutes, and I think we'll be back online. Okay.
Mhm.
Thanks.
No
Sorry
problem.
about this again.
No problem. Thank you.
Okay, it looks like Judge Alvaro is back with us. Judge, can you hear us? We can see you without video on Zoom. Can you hear us? It looks like you're muted. There we go.
All right.
Where there's
Okay.
a will, there's a way.
There we go. All right, wonderful. Can you hear us, Judge Alvaro?
I can. Can you
It
hear
looks
me
like-
okay?
Yes, it looks like you had to move to a place with a better signal.
I did. I had to come down a mountain at fairly rapid speed and get into a cell phone area. We lost Wi-Fi connectivity in the whole house. The whole power in the house went down. All the lights, everything.
No worries. It can happen to anyone, and we're all sort of at the mercy of the technology. Thank you for everybody for sort of sitting tight and patiently waiting. And thanks, Judge Alvaro, for staying with it and rejoining us. And with that, counsel for the appellee, we interrupted your argument. You have 15 minutes and 6 seconds remaining, and you can proceed whenever you're ready.
Thank you, Your Honors. And I think the point I was making, and I don't know how much Judge Alvaro heard or missed out on, was that focusing the argument somewhat on the standard of review that we have here. I believe,
counsel, if it helps, Judge Alvaro will go back and review whatever part he did miss before decision. So just so that that will happen. Go ahead.
Thank you. And I know in appellant's brief they wanted to argue for a side-by-side comparison, and I'm not sure that even helps them, because if you do a side-by-side comparison, this letter does not match up to what's required in the mortgage. And one of the primary objections I have to it, as I discussed, was the right to reinstate after acceleration. Is a very critical right. You have the right to reinstate after acceleration by paying the cure amount, not by paying the entire balance of the loan. But their letter here says after the times expire for acceleration, you can prevent the foreclosure by paying the entire balance of the loan. That is inaccurate. So it's not a face-to-face or comparing it side by side, it fails. But when you also throw in that the homeowner in this case testified that she didn't just rely on that. She actually called the bank and asked them what it takes to cure this. And they told her repeatedly that she had to pay the entire balance of the loan. Now the amount kept changing, but they always went back to you have to pay the entire balance of the loan. And the judge had that within him to review that and compare that to the letter and say, okay, was this confusing? Did it in fact confuse this witness? Now the bank at some point made an argument, and I think they did it at trial, and I think they said in their brief, well, that she admitted that the bank told her that she could cure just by paying the cure amount, the amount of the default, not the entire balance. And there was some testimony of that, but it became clear on redirect from her attorney that the only times that the bank said that she could cure by paying, the default amount was after the foreclosure prior to the foreclosure, she was being told she had to pay the entire balance of this loan. And this gets to the standard of review in this case. The only way you could overturn the trial judge's decision is if you reweigh her testimony different than he did. She actually stated this is what they told her to do. And the bank presented some evidence that they never said that. There's no business record that says they ever told her that. But then again, you're getting into weighing evidence. And that's not, with respect, that's not this court's prerogative. The trial court's the person who gets to weigh that evidence, and he did so. So I think the only way you can actually overturn this decision is to take it upon yourself to reweigh the evidence that the trial court heard and balance it differently than he did. And I think your honors understand, know that.
You mean on the issue of prejudice?
On the issue of substantial compliance, and it does dovetail into prejudice. And I can explain that. You could see that this does not substantially comply just by the language that they used here, but also when they told her on the phone that she had to pay the full balance. That does not comply with those requirements.
And I mean, we're part of what I think we're trying to do here is sort out the law and the sort of the steps, right? So is it your position that substantial compliance cannot, once we take the historic facts as found by the trial court, is it your position that then that's unreviewable and that the trial court's conclusion is also a question of fact that we can't review? Or is it that based on all those historic facts that the trial court found, then is the question of substantial compliance de novo review?
No, I think the question of substantial compliance, and again, I cite back to the case, the Morton case, because the Morton case establishes affirmatively that is a question of fact. It cannot be de novo review. And this court has said in many cases, so as the Supreme Court, when it comes to questions of fact, deference is given to the trial judge, and you cannot reweigh that. It is not the province of this court or any appellate court to do so.
So you're suggesting that the actual conclusion of whether there was substantial compliance with the contract, right, is a unreviewable question of fact?
No, what I'm saying is in order for the trial court to get to the conclusion of whether or not it was substantial compliance, it did and properly could do weigh the evidence presented at trial, not just the letter itself, but the testimony of the homeowner saying, in fact, not only did this letter tell me this is the way I interpreted the letter.
But that would go to prejudice, counsel. That wouldn't go to substantial compliance. I mean, the impact on your client, wouldn't that be more testimony relevant to prejudice rather than testimony relevant to whether or not the deficiencies were material?
I think it's overlapped on both of those. I think it can go to substantial compliance because the notice provision requires the bank to inform the homeowner of the right to reinstate by just curing the default. And again, that obviously the mortgage in paragraph 24 refers to the letter, but if the homeowner is actually also getting that information from the bank by phone, I think that just doubles down on the fact that they didn't substantially comply with the notice requirements. The information they were supposed to impart upon the homeowner, they did not do. And in fact, they confused her on that issue, but it also goes to the prejudice.
Well, they were supposed to, I guess, I mean, I hear what you're saying. I'm not sure I agree with your analysis that they're the same thing. I think that the impact, I don't understand why the impact on your client, I understand how that goes to prejudice. That's clear. But the impact on your client seems like it would only go to prejudice and it would not go to whether or not the contract was substantially complied with, whether the terms of the contract were substantially complied with. You see what I mean? In other words, why isn't the materiality of, hey, this notice letter left out A, B, and C? Is A, B, and C material, right? That's the question. Is it material? It really has nothing to do with the materiality has nothing to do with the impact on your client. Prejudice would relate to the impact on your, how your client understood it, how your client acted, how your client frankly didn't act because of it, right? That's prejudice. But the materiality, just the interpretation of what did this contract require and were these terms material? Why is that not a question of law?
I'm sorry, I'm not sure if I understand your question. I do agree with you that it does also go to prejudice, because if the bank is telling her the wrong information on the phone, she's absolutely prejudiced in the sense that if she actually has the right to cure or reinstate this mortgage by paying just the amount of the default, which is $3,000 or $4,000 or $5,000, or whatever it was at the time, and they're telling her, no, we're not going to accept that. You have to pay the full balance. That's an obvious prejudice. I think everyone can see on the face of that it was a material term of this mortgage for them to inform her of a right to cure, not to pay the full balance. I think it goes that, and that's why I think it does go to prejudice. I think you're correct on that, but I do think it goes to materiality, because this was probably one of the biggest rights you have under that mortgage, to be informed. Now, we could make a distinction whether they put it in writing, they put it on the phone, but critical to it is that the bank informing.
But didn't she have a right to be informed under the mortgage, under the contract? She had a right to be informed whether or not she was prejudiced, right? The contract says you have a right to this. And it really doesn't matter if your client, wanted the information or was prejudiced by not having the information. The contract says this is the information you get.
And this might go back to the question you were asking appellant, is if you make a determination that they didn't substantially comply, do you even have to look at prejudice? And I think it's a great question, because the case law can get kind of murky depending on what case you look under that. I'm not aware of one off the top of my head that specifically addresses that issue, but the cases that do discuss substantial compliance with prejudice, they do analyze them together. And since I think one of the honors, I forget which one stated it, you only look at prejudice once you determine there's substantial compliance. Okay, you didn't technically comply, you substantially complied, but if there was still prejudice, we can dismiss this. So when you determine that there is no substantial compliance, I don't think you even get to the prejudice issue. And I can argue.
Yeah, that was a major question earlier in the argument of, does prejudice go with substantial compliance, or do you not even get there? And your position is, hey, look, if there's no substantial compliance, the court doesn't even need to look at prejudice.
Correct. I think that's true. And not to beat a dead horse, I don't think there's any way to find substantial compliance in this case or lack of prejudice unless you unless you completely reweigh the testimony here differently than the trial court did. And you just, with respect, again, the appellate court just not in a position to do that.
I guess that's the major point of question, I guess, for me, is the materiality of a contract term. Why is that not a question of law?
The materiality of the contract term would be a question of law. Whether the person performed and the evidence established that somebody performed that contract, that would be a question of fact.
Let's say the trial court, as largely in this case, says, hey, you didn't perform it, you left out A, and you tried to do B, but you said it in a way that was incredibly inaccurate. Therefore, those are the trial court's findings. And here's the notice letter. You can see it right there. It's missing A entirely. B is stated in a way that is entirely inaccurate. Why isn't it for the appellate court then to review the notice letter, the mortgage, and the trial court's findings, right? And by the way, there could be additional findings based on testimony, like, hey, the letter was sent to the wrong address, right? But once we have all those historic facts that are given to us by the trial court, why is it not a question of law then for us to determine whether or not compliance with that contract term that the trial court said wasn't complied with, what was compliance material? Was it a material term? Why isn't that a question of law?
I think we might be saying the same thing, but I'm not communicating it well. I agree as to whether or not a contract term is material would be a question of law de novo. But I don't think in this case, I don't think there's any question that this provision here is material to the parties bargaining. It's in paragraph 24, which is in bold print, the only paragraph in bold print, the only paragraph that specifies a borrower's rights. So there is no argument that it's not material. There is no argument they didn't comply with that part of the business where it talks about being able to reinstate after acceleration, because they state the exact wrong information. So yes, whether it's material, I think you would rule as a matter of law that is a material. It was a material breach on their part, or at least a material non-compliance. I think the evidence supports that they didn't comply. I don't think we even need to get to prejudice, but to the extent we do get to prejudice, the prejudice is obvious. When you have the right to cure or reinstate by curing by paying the default amount, and they're telling you can't, you have to pay the full balance, and wait until after the foreclosure to tell her she has the right to cure.
When it was too late.
that it's too late. The attorney fees have racked up. She's got attorney fees. They've got attorney fees. You got court costs, and that's where they left her here. So at that point, that prejudice is on its face. And when you add in the fact that she called them and they told her this on the phone, when you add in the other parts of this notice that don't comply with the mortgage, I just don't see how you ever get to a place where you say, yes, the court erred as a matter of law by holding out these material terms, or two, that she wasn't prejudiced, even though she stated that in fact she was.
Well, it sounds like you would agree that
I don't see any way to overturn the Frank. I mean, I know I'm biased here, but I just can't see any way that this court can overturn the trial court's findings, whether on a question of law or a question of fact.
Sure, I understand because that's the argument, your client's best argument. And so I guess what I hear you saying is the first question, at least as you've laid out the sort of the law, the first question is, was there substantial compliance? We accept the trial court's historic facts if they're supported by competent substantial evidence. And we review, based on those facts, we review whether there was substantial compliance as a matter of law. Then if we find there's substantial compliance, then we still must look at whether there was prejudice, which the trial court, then that point, that's a lot. There's a lot of questions of fact that we have to defer to if they're supported by competent substantial evidence, and we can't reweigh evidence at that point, right? Is that essentially what you're saying?
That's a pretty good summary, Your Honor.
Okay.
But to your point, Mr. Bowen, I mean, to reverse on this record, couldn't this court, conducting a de novo review, simply conclude that the trial court's determination that the language was confusing was, as a matter of law, not confusing? I mean, isn't it a pure matter of contract interpretation?
No, I don't think so. I think it's a great question, because I think you could consider the party's interpretation of that notice that came to them, and I mean, ultimately, it's the parties who get to decide what's confusing or not. The agreements between them, the letters between them, and the homeowner in this case.
Okay, I mean, now we're circling back to my question. I mean, in every circumstance I can think of, interpretation of a contract is reviewed de novo.
An insurance policy, for instance. I mean,
but we're not.
Is an appellate court required to give deference to a trial court's interpretation of an insurance policy? That would seem unusual.
No, but when we're looking at this notice, the notice itself isn't the contract; it's the performance of the contract. So you're not reviewing that de novo. You're reviewing whether or not they complied, whether they performed their obligations of the contract, and that would be a question of fact, which I don't think you can overturn. There was another point I was going to make. I only got 20 seconds. I don't think it was going to be a winner. And it's not something I want to spend the rest of the court's time on. So if you have any questions for me that I can answer, I'd be happy to.
Okay, thank you, counsel.
Thank you, Your Honor.
All right, and counsel for the appellant, looks like you have 3 minutes, 44 seconds left for your rebuttal, and you can proceed whenever you're ready.
Thank you, Your Honors. First off, I would disagree about the competent substantial evidence that was provided at trial. I would disagree with what yielded. But the getting to the substantial compliance and based on the case law of the 5th DCA, I think that in order to find whether or not there was substantial compliance, you have to ask whether or not the breach was material. And if the breach was not material, then there was substantial compliance. Our argument is that the breach was not material in this case because there was absolutely no prejudice. And I understand prejudice gets teased into that. And I don't know that you can untangle prejudice from the determination of whether or not a breach was material. I think you have to go to that in order to determine whether or not it was material. But the bottom line is that the court in this case did not even address whether or not the breach was material. The court just went to say that there was no substantial compliance and therefore this case is dismissed. The problem—
isn't that the same thing? I mean, you just said that substantial compliance is determined based on materiality.
Correct, but there were no findings of fact as to what was material.
Wait, but I think that logic is almost circular. I mean, the idea that to look at materiality, we have to look at prejudice to determine whether it was material, such that we have to look at prejudice. I mean, prejudice is after a determination of substantial compliance, and I don't think it's bound up in substantial compliance.
Well, if it's not, I defer to your honors, but there still has to be an examination of whether or not there was prejudice in order to find whether or not there was a breach, whether or not there should be a dismissal, because otherwise then you wind up in a situation where you're demanding strict compliance and verbatim statements of what is in the paragraph of the mortgage that provides the notice requirements. In this case,
let's talk about that. I kind of took issue with what you intellectually with what was in your brief regarding I think it was something to the effect that these notice provisions are gotchas to prevent lenders from foreclosing after default. I mean, at the end of the day, these are notice provisions that are prepared by the lender on lender's form documents where the borrowers have no input as to the contractual terms. I mean, why is it a gotcha to require the lender to comply with its own work product?
I think that that was not the intent of the meaning of the brief. It was just that that there should not be a dismissal without prejudice just because there was not strict compliance. That was the point of it. And then
counsel, I think the problem here, we're definitely still missing each other, I think, but I think the problem here is that it's not a question of strict compliance, right? The law clearly says that you can substantially comply. So the question is did you substantially comply? And then the second question is, how do we determine substantial compliance? You're making the argument that we have to look at prejudice to decide whether there's substantial compliance. The appellee says, no, substantial compliance is the first question. And then if you have substantial compliance, but something that falls short of strict compliance, then you look at prejudice. Right. So no, I mean, nobody's saying that the lender has to always strictly comply.
Right.
On either side, I don't think.
And when there's substantial compliance, the lender is giving the borrower something less than what was bargained for, right? They're taking something less. And the defense to the borrower is, well, it only matters if you're prejudiced. Isn't that why it's the second part of the analysis and not the first?
Yes, ma'am. The key, I think, is whether or not the breach was material in order to find whether or not there was substantial compliance. And that is an issue that I don't think that the trial court addressed.
Okay, counsel, your time has expired. Thank you. It was well argued on both sides. And with that, we are adjourned.
Thank you.